Judge. If the defendant could get obtain a device, Judge, this is his third DWI arrest.
On what we're talking about? Who? CR 20
Yes.
02991D.
Yes, Judge.
Your Honor, at this point in time, Your Honor, I don't know if there were convictions or not. That's what I would have liked to have gotten in the discovery. Or are these just
Statute doesn't require a conviction. It'd be third arrest, Judge. Subsequent arrest.
Okay.
I understand that, Your Honor, but at the same time, I think it's discretionary upon the court if it's necessary. But I don't know if those dispositions were unfound. I mean, were they not guilty? Were they dismissed? I understand the state's position, but at the end of the day, I'd ask the court to use their discretion. And the fact that he's had this charge since 2020 and hasn't had any more issues with it, I would ask the court to consider not ordering an interlock device at this time.
Okay, but I think Mike is saying, regardless of whether they were dismissed or not, I think he's saying just because there were 3 arrests, is that what it is?
Yes, Judge. According to Article 17.44(1), Judge, if the defendant is charged with a subsequent offense of DWI. So
17.441. Okay.
I think it goes on, does it not, sir, with regards to the discretion of the court to issue that interlock device?
Well, it's required.
Let me look into it.
Okay.
17.441.
Yes, Judge.
Let me look, and then by June 13th, I will give a decision.
Thank you,
or even before. Okay.
Thank you, Your Honor.
Let me look into it. 17.441. We're talking about CR 20 02991D Manuel Rodriguez, right?
Correct, Your Honor.
Okay. So for right now, June 13, 10 a.m. PT pre-trial.
Thank you, Your Honor.
All right.
Can you call the client? Wait.
Yeah. Yes. Okay, Mr. Montalvo, call the client so he won't.
Yes, Your Honor. I will.
He's trying to get on. All right. Thank you.
Thank you, Your Honor. Thank you.
Who we have next?
Number 2, Ms. Dora.
Miss Dora Garza. Good morning, ma'am.
Good morning, Your Honor.
By the way, court is here on the April 27th, 2022 docket, and we're proceeding here on YouTube. And Ms. Garza, you're next. Your client is CR 20 06186D. Jacqueline Castor.
Yes, Your Honor.
Connecting.
Okay, I understand she's connecting right now. We're gonna place her on PTD.
That's correct.
All right, let's get her on here.
She needs to unmute.
All right, Miss Castor, you need to unmute. Can you hear me?
She needs to unmute.
Can you hear me? I don't
She
hear
can
you.
hear you, but there you go.
Okay, now can you hear me now? All right. All right, she needs to unmute. There it is. She unmuted. But there's no audio.
I can't.
All right, we don't know.
Check your speaker, check the volume.
Or Jacqueline, if you have your phone, you can call me and I can put you on speaker.
Yeah, let's try speaker here.
Let me get my phone.
Okay.
Just make sure that you speak up so that it can come out, okay?
Okay.
There you go. Yeah, thanks.
All right, Miss Castor, can you hear me now?
Yeah, I could hear you before. It's just, I think my speaker's not working.
Okay. Okay, now I'm getting some other noise.
I lowered the volume, see if that helps.
Okay. All right, let's try it here. CR 20 06186D, Jacqueline Elizabeth Castor. It'll be a plea, and we're going to be placing you on PTD. Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes.
Speak up.
Can you say yes?
Yes.
All right, say it loud enough so we can hear you on the speaker phone. Your case, DWI, Class B misdemeanor, it carries a potential, you can put your hand down, it carries a potential penalty of up to 180 days in jail and not more than a $2,000 fine upon conviction. You understand that?
Yes. Yes.
You understand that you're entitled to a jury trial, you're entitled to an appeal, and that you waive those two rights?
Yes.
Have you ever been declared mentally incompetent?
No.
You understand that the court does not have to follow the recommendation after you give a plea?
Yes.
And what is your plea, ma'am? Guilty or not guilty? Well, to be on the program, you got to plead guilty.
I'm guilty.
All right. And are you pleading guilty freely and voluntarily?
Yes.
All right. State.
Yes, Judge. State offer plea document and offense report as Exhibit 1, notification and certification of defendant right of appeal as Exhibit 2, waiver of Article 39.14 disclosure as Exhibit 3, waiver of risk and need assessment as Exhibit 4, PTD PAC as Exhibit 5. State would also request defense counsel to stipulate to the venue and jurisdiction of this honorable court, and to also stipulate that evidence has been filed sufficient to appropriate guilty.
No objection, Your Honor, and so stipulated.
Without objection, so admitted. However, at this time, the court will withhold any finding of guilt or innocence and will suspend any judgment in this matter and will now turn to the PTD program, in which everybody has signed and I think it's been approved by the court as well. All we ask here, Ms. Castor, is follow the terms and conditions of the PTD program, and hopefully down the line we can dismiss this case. For right now, we'll set it for status December 7th, 9 o'clock. December 7th, 9 o'clock for status. Yes, ma'am.
Judge, I did want Your Honor to consider waiving condition G. Ms. Custode will be going to Houston, Judge, I believe she'll be a nanny for one of her older brothers, and that'll help her pay her fine and her court costs.
Okay, waive condition G. That is a restriction to this county, right?
Yes, Your Honor.
Okay, so remember the date, December 7th, 2022, 9 a.m. for the first status hearing. Hopefully we'll get a good report. Okay, ma'am? All right, good luck with that. Your excuse and have a great day.
Thank you.
Thank you. Bye-bye.
Number 8, Mr. Abel Garza.
Thank you, Your Honor.
Thank you, ma'am. Mr. Abel Garza?
I need the name of the victim.
Okay, Mr.
Yes,
Abel
Your Honor.
Garza, good morning, sir. You
Good
represent
morning,
CR
sir.
2202864, the Jose Martinez?
Abel Garza for Mr. Martinez, Judge.
All right, he's on and he needs to unmute. And then we're gonna hear some testimony, State.
Yes, Judge.
And who's the person?
Alma Vasquez is the victim.
Alma Vasquez. All right, let me look for Alma Vasquez. I don't see Alma Vasquez unless she uses somebody else's.
Mr. Garza.
Yes,
was,
sir.
Was she supposed to appear in your office? Because remember,
She wasn't able to right now because due to her employment, her work, but I think she's in a completely different location.
So she didn't have the information for today's.
No, she should be available, but if we need more time, we'll be asking for that. But
Okay, because I don't see her in the waiting room.
And he's not under that name unless she's using someone else's device and she's under another name. We need to know.
I see Valeria's 852. I see Perla's S21, and everybody else has a name. But
I had advised them about coming on and with her name. If I can try to contact her, Judge.
Yes.
yeah, try to call her right now, and we'll skip you for a while, and we'll come back. Alma Vasquez, we're looking for her. Okay, next.
When someone is not, Carlos is not. We're needing Attorney Carlos Galvan and Attorney Juan Zamora. And they're not in the waiting room.
Juan Zamora and Carlos Galvan. How about Alejandro Munoz?
No, that one's taken care of.
Okay, even this
Okay,
one?
now go to the civil. I'm gonna do number 1. I've got Rogelio Garcia, Mario Garcia,
Okay.
Roger, Mario. And I need to know who is
You said Mario Garcia.
plaintiff.
All right.
to know who we're missing.
I need Mr. Roger Garcia, Mr. Mario Garcia.
Miss Ida, on
Yes,
CO 22-0387D, number 1 on the docket.
yes.
Gracie Orellana is the attorney for the plaintiff.
Okay, yes, thank you. She's here.
Graciela, we have her.
Okay,
Okay.
thank you. Gracie.
Rogelio Garcia. Orellana. All right, Mr. Garcia, there you are, Mr. Roger Garcia.
Yes, sir.
And now we need Miss. Good morning, sir. We need Miss Orellana. There she is. Good morning.
Good morning, Judge.
And I think we need Mario Garcia. And he's connected.
El primo.
Your cousin got the same name. Okay. There he is, Mr. Mario Garcia. Needs to unmute.
I'm sorry, I just finished a hearing with the Honorable Jay Palacios in Court 2.
Okay, thank you, sir. Are you ready for the friendly suit, Mr. Mario?
Can you hold on a second, Your Honor?
Sure.
Who do we need?
My client should also be logged on, Judge. I'm not sure if you can see them on your side.
And her name is Iracema?
No, Maria
Garcia
Navarro.
and Arturo Garcia. Sorry, Iracema Martinez and Arturo Garcia.
Iracema Martinez and Arturo Garcia. It's Arturo Garcia. I think they're together.
Yes.
Arturo Garcia. I see Arturo Garcia. Man, there's a lot of Garcias in this case, Miss Oriana. You don't want to change it? You don't want a name change?
I'm sure my husband would have something to say about that, Your Honor.
Too many Garcias here in this case. We got Arturo Garcia, Iracema Martinez, and I think they're checking in. I think they're in already. All right. Can they hear me?
Yes.
Yes.
All right. Very good. Very good. Okay. So then we have, okay, now I think Mr. Mario Garcia just disappeared, but it's coming back already.
There you go, Your Honor.
Are you ready, Mr. Garcia?
Yes, sir. I'm sorry. We just finished up the Court 2 matter. It was pretty good.
Okay.
I had to wait for it.
Okay, so we're here on, first of all, the April 27, 2022 docket, and then CL 220387D, Arturo Garcia and Iracema Martinez as next friends of minor versus Tina Gorena. And for the record, I think everybody is here. Would you please give your names for the record?
Good morning, Judge Graciela Orellana for the plaintiffs.
Your Honor, Rogelio Garcia for Tina Gorena and Jeremy Ryan Gorena, defendants.
Okay.
Good morning, Mario Garcia, the guardian ad litem for Anthony Garcia and Leslie Marie Garcia, Your Honor.
Anthony and Leslie Marie. There we go. All right. Miss Orellana, you going to get started?
Yes, Your Honor.
And you're going to call first who?
Miss Iracema Martinez?
Okay, Miss Martinez, can you hear me?
Yes, I can.
Okay, good morning, ma'am. Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down and listen carefully to the questions. Miss Orellana, you may begin.
Thank you, Judge. Ms. Martinez, may you please state your full name for the record?
Iracema Martinez?
And you are the mother of Anthony Garcia and Leslie Marie Garcia, correct?
Yes.
And we're here today because of an auto accident that occurred back on January of 2021 here in Hidalgo County, correct?
Yes.
As a result of that accident, both Anthony and Leslie sustained injuries, correct?
Yes.
And they received treatment for those injuries as well, correct?
Yes.
And they are doing well? Their injuries have resolved?
Yes.
As to, and we are here today because you have reached an agreement on behalf of both minors, correct?
Yes.
As to Anthony, they've agreed to pay $13,800, correct?
Yes.
And as to Leslie, they've agreed to pay $12,700, correct?
Yes.
Regarding Anthony, of the total settlement of $13,800, you are asking the court to pay $10,501 to the law office of Ezequiel Reina for medical expenses, case expenses, and attorney's fees, correct?
Yes.
The remaining balance of $3,299 will be deposited into an interest-bearing account in the registry of the court for the use and benefit of the minor child, correct?
Yes.
As to Leslie, of the $12,700, you are asking the court to pay $9,450 to the law office of Ezequiel Reina for medical expenses, case expenses, and attorney's fees, correct?
Yes.
And the remaining balance of $3,250, we are asking the court to be paid directly to Ms. Leslie, who will be turning 18 on May 6th, correct?
Yes.
Okay, and you realize that once the judge approves this settlement, you will not be able to come back and try to reopen the case on behalf of either minor, correct?
Yes.
And the money deposited into the registry of the court is for the use and benefit of the child, and you will not be able to withdraw the money without permission of the court. You understand this, correct?
Yes.
And you understand that we're here today to announce a settlement, and you are asking the judge to approve both of these settlements, correct?
Yes.
Your Honor, I have no further questions. I pass the witness.
Thank you, ma'am. Mr. Roger Garcia?
Yeah, a few questions, Your Honor. To begin with, I believe Anthony turned 16 today, so happy birthday to Anthony Garcia.
Thank you.
Happy birthday, Anthony.
Thank you.
And I understand that Leslie will be turning 18
On May the 6th.
on May the 6th, a week
May
from
the
this
6th.
Friday. So we're asking the court if we could go ahead and bypass depositing into the court's registry and giving her a check as Ms. Orellana just approved on the record.
Okay.
If the court approves. All right. So
That'll work.
just a few questions, quick questions for Ms. Martinez. Do you understand, Ms. Martinez, that the money that will be deposited into the court's registry for the interest of Anthony Garcia will be in that account until he turns 18 or Judge Garza allows a withdrawal by court order? Do you understand that, ma'am?
Yes.
Do you understand that you have a right to a jury trial, but where a jury could award more or could award less than what is being proposed as settlement, but you, on your own behalf, have decided to waive that jury right? Is that correct?
Yes.
And you prefer to proceed to ask this honorable court to approve settlement?
Yes.
Do you believe that this is a fair and just settlement for your children?
Yes.
Now, you're going to be asked to sign what is called a settlement agreement and release. Do you understand that by signing and executing that release, you nor your husband or your children will have any additional claims or funds available for this specific accident? Are you aware of that?
Yes.
And knowing that, you still prefer to move forward to asking this honorable court to approve the settlement. Is that correct?
Yes.
And is this in the best interest of your children?
Yes.
Your Honor, that's all I have. I'll pass witness to Mr. Garcia.
You mean Mr. Mario Garcia, right?
Thank you, Mr. Roger Garcia.
Yes, sir, Mr. Garcia. Okay, thank you, Mr. Marcus. Thank you, Mr. Roger Garcia. Now, Mr. Mario Garcia.
Thank you, Roger.
Thank you, sir.
We have all stars today. Mr. Roger Garcia is present with us. So, Ms. Martinez, hello. This is Mario Garcia. Do you remember speaking with me a couple of weeks ago?
Yes, sir. Good morning.
Good morning. And good morning, Anthony. Happy birthday.
Thank you.
And good morning, Leslie and Marie. How are you doing this morning?
Good morning. I'm doing good.
Do you also, Leslie and Anthony, remember speaking with me regarding your cases?
Yes, sir.
Okay. And Ms. Martinez, you've heard some of the questions, you've answered some of those questions in the positive as regarding your opinion that in totality of the circumstances surrounding this case, you feel that it is in the best interest of each of your children that the court approve the proposed settlement for each child. Is that correct?
Yes.
And let me go to Anthony. Anthony, when I spoke to you, as you recall, this accident, your claim arises from the accident that happened on January 15, 2021. Is that correct?
Yes, sir.
And we went over your medical records and your medical bills. And as part of our discussion, you mentioned to me that although you had you complained to the doctor of back and neck pain because of the accident, since the accident, you've gone to some medical treatment and the doctor has released you. Is that correct?
Yes, sir.
And the doctor released you without any physical restrictions as far as any things you were able to do before the accident, such as going to school, maybe being involved in physical activities or sports. Is that correct?
Yes.
And as you sit here today, are you telling the court that you feel well enough that you also approve that this case, that your settlement should be approved by the court?
Yes, sir.
Do you feel that the proposed settlement is in your best interest?
Yes.
And going to Leslie, also similarly with you, you went to the doctor complaining of pain to your neck and back, and basically it's from the same accident that occurred on January 15, 2021. Is that correct?
Yes.
And we discussed that you had sought treatment and you received good treatment for your neck and back, and you were released from the doctor eventually without any physical restrictions. Is that correct?
Yes.
And as we sit here today, would you approve of this settlement if the court allows it? Do you think it's in your best interest?
Yes.
Now, specifically for you, since your birthday is coming up in May, on May 6th, you'll be 18. Is that correct?
Yes.
And you're asking the court that instead of depositing the net proceeds from your settlement into the registry of the court, you're asking the court to allow your mom and the defendant to basically send a check for the full amount and bypass the court's registry system, and that would be the amount of $12,700 for the check to be made in the name of your name and your attorneys, which would have to be issued on or after May 6th of 2022. Is that correct?
Yes.
Okay. And going back to Ms. Martinez, on the settlement to be paid to your son, you understand that the total settlement amount is proposed to be $13,800.
Yes.
And deducted from that are going to be the medical bills from ASP Cares Pharmacy, Carol Sync Health and Wellness Chiropractic, Digital Views, Open MRI at McAllen, and Physicians Injury Clinic. Those total bills would then be reduced, and from the settlement of $13,800, and then also there will be an amount of $4,400 for attorney's fees. You understand that?
Yes.
There's also, Mr. Reina has some case costs of $51, and that will be deducted. So the net amount that will be proposed to be deposited in the registry of the court is $3,299. You understand that, for your son, Anthony?
Yes.
And again, as Mr. Roger Garcia stated, asked you, this will be, there are no further monies will be coming in the future. If there are any complaints of any issues, you understand that this is a full and final settlement. The case will be closed in that regard. And you cannot come back, or either of your children cannot come back and ask for more money from the defendant. Is that correct?
Yes.
And to your understanding, there were other claimants in the vehicle at the time of the accident, correct?
Yes.
And so basically, with the payment of this settlement funds to your children, that would exhaust the policy limit that was applicable in this case, which is $30,000 per person, $60,000 per accident, correct?
Yes.
Okay, so in other words, that's all the money that you could recover from the defendant through their insurance policy, correct?
Yes.
Okay, and again, you had a right, like Mr. Garcia asked, you have a right to go to a jury trial and try to get more money, but you've decided to resolve this case because this basically, you settled for the policy limits. Is that correct?
Yes.
And again, just one final time, are you asking the court to approve the proposed settlements for each of your children because you feel that in each case, it's in their best interest?
Yes.
And you're asking that the court bypass the traditional manner of depositing the settlement proceeds for Leslie Marie Garcia, your child, and to wait until May 6th for or to receive the settlement agreement from the defendant because it's only 1 week to her birthday, and it would be against her best interest if the court deposited these funds in the issue of the court, and it would just be for a matter of 8 days. Is that correct?
Yes.
Thank you, Your Honor. That's all the questions I have. And Your Honor, based on the circumstances of the accident, the injuries claimed by each minor, the medical treatment given to each minor, and the fact that the entire policy limits were pretty much pitched forward to the plaintiffs in this case, we asked the court to approve each of the settlements as proposed. And again, with Ms. Leslie Marie Garcia, that she'd be allowed to wait another till May 6th to formally settle her case, because then that would deter and prevent really something that would not be fair or just for her just to wait 8 days, for the court to deposit this.
All right, very well. Any more questions from anybody else?
Oh, I have one more, Your Honor. I'm sorry, one more.
Okay.
Ms. Martinez, is your husband, is he in approval of this particular settlement? I know that he's listed on the petition, and your husband, Arturo Garcia, have you spoken to him about what we discussed today in front of the court?
Yes. Mm-hmm.
And has he given you his consent and approval and his opinion that these settlements are in the best interest of each of the children?
Yes.
That's all, Your Honor. Thank you.
All right, court will take judicial notice of the entire file in CL 220387D in the case of Arturo Garcia Jr. and Iracema Martinez as next friends of minors versus Morena et al. Court will hereby approve the minors settlements, and of course will also approve the direct payment to Leslie Marie Garcia. Anything else?
Nothing further on my part, Your Honor.
All right.
There should be I'm sorry. There should be a proposed judgment filed pretty soon, I guess.
Okay, court will await a judgment for signature. Anything else, folks?
The final judgment has been circulated. Mr. Garcia has signed it and returned it. Ms. Orellana, if you could please return it, we'll go ahead and file it as quickly as it's brought back. I will also circulate a release, Your Honor, for Ms. Leslie Garcia to execute after she turns 18. That way we can have everything situated as the court has ordered.
And Mr. Mario Garcia's fees have also going to be included?
That has been discussed, and it will be included in the final judgment. Yes, Your Honor.
Okay, very good. Thank you very much. You all may be excused. Have a great day and stay safe.
Thank you, Judge.
Thank you,
Roger. All right.
Roger,
thank you all.
Roger, I apologize to the judge for this morning's snafu. Roger knows what I mean. Thank you. Thank you, Roger.
All right. Thank you. Bye-bye. Y'all have a great day. Thank you.
Mr. Abel Garza, could the victim be Alma Mendoza?
Mr. Garza, could the victim be Alma Mendoza?
Yes, it is.
It is? Okay, let's use that. Okay.
Yes, Judge.
So I know we asked earlier, and it was Alma Vasquez.
Yes, I apologize about that, Judge.
All right. And
She's connected, right?
Okay, and I want to have Mike available, Ms. State.
And she might need services
Interpreting?
of interpreting. Yes.
All right. Let's ask her first if she'll need her. And Mr. Gwynn, you ready, sir?
Yes, sir.
All right, court will continue here with the April 27th, 2022 docket. And once again, CR 2202-864D, Jose Martinez. He's there, and so is Mr. Abel Garza, his attorney. And I think we have Alma Mendoza.
She's connecting.
Okay, she's connecting.
When that happens, we can go to Mr. Zamora, number 6 and 7.
All right, she's trying to connect. So now we're gonna do another case here. 6 and 7?
Yes.
Okay.
Right here.
Mr. Zamora, can you hear me? Trying to get Juan Zamora here. Abel, can we put her on speaker?
Yes.
Can we put her on speaker and maybe she can listen to all of us talk and she can respond on the phone? Call her. Who's got the number?
Or Ms. Mendoza?
Yeah, who's got Mr. Mendoza's number?
I have it, Judge.
What? Yeah, color and put on speaker.
Very well.
Let's go that route. Mr. Mendoza, can you hear? Mr. Zamora, can you hear me? No.
Sí, Alma, la vamos a poner porque no conectaste por el sonido, por la voz. Ok, no tiene, te voy a poner en mi bocina, en mi teléfono. Ok, escuche.
Okay, Alma, can you hear me?
Alma, ¿escuchas?
Sí,
Yes.
Oh, okay, good morning, ma'am.
Buenos días.
buenos días.
Good morning.
All right, Miss Alma Mendoza, you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Alma, ¿juras que el testimonio que vas a dar es la verdad, solamente la verdad y nada más que la verdad?
Sí,
Yes.
All right, Mr. Nguyen, you want to get started?
Yes, Judge.
Okay.
Please state your full name for the record.
Alma, el fiscal te va a preguntar unas preguntas. La primera pregunta es tu nombre completo.
Almadelia Mendoza Vázquez.
Okay. What is your relationship with the defendant?
¿Qué es José Martínez de usted?
Mi marido.
My husband.
Okay. Can you tell me what happened on or about January 12th, 2022?
¿Me puedes decir brevemente, qué fue lo que ocurrió el día 12 de enero de este año?
Estábamos discutiendo y me pegó una cachetada.
We were arguing and he slapped me.
Okay. Is there a history of violence in your relationship?
¿Hay historia de violencia en tu relación con él?
No,
No.
Are you concerned about any future violent acts?
¿Y tienes miedo de que vuelva a ocurrir en el futuro?
no,
No.
Did you fill an affidavit of non-prosecution with the DA's office?
¿Y tú llenaste una declaración en la oficina del fiscal?
sí,
Yes.
Did you fill it out on your own free will?
¿Y tú la llenaste voluntariamente? ¿Esa declaración tú la llenaste voluntariamente?
sí,
Yes.
Nobody promised you anything or threatened you in any way to get you to sign the AMP?
¿Nadie te prometió algo o te amenazó para que tú firmaras esa declaración?
no,
No.
Do you wish to drop the charges against the defendant?
¿Y tú quieres retirar los casos?
sí,
Yes.
Okay. You do understand that by dropping the charges, this case cannot be open in the future, correct?
Tú comprendes que si la corte retira estos cargos, entonces ya este caso se cierra.
sí,
Yes.
However, you do understand that if another incident was occurred, you can open a new case, correct?
Pero si en el futuro esto vuelve a ocurrir otra vez, tú comprendes que tú puedes archivar cargos nuevos.
sí.
Yes.
Judge, the state passes witness, Judge.
Mr. Garza, do you have any questions of the witness?
No, Your Honor.
All right, thank you, sir.
I don't think we need an interpretation of the bird tweeting, Judge, because it should be identical.
Oh, okay. Okay.
Apologize.
All right. And Mr. Nguyen, yes, sir. You had an announcement?
Yes, Judge. Defendant have completed the English marriage course. The AMP is on file. The state will move to dismiss this case, Judge.
All right. And we're talking about CR 22-02-864D?
Yes.
That case?
Yes, Judge.
Court will hereby dismiss CR 22-02-864D, State versus Jose Martinez, case dismissed. All right, that'll do it. Thank you for your testimony, Ms. Vasquez.
Thank you, Your Honor.
And that'll do it, Abel. You'll have a good day. Stay safe, okay?
You too, Judge. Thank you.
Okay, bye-bye.
Very much.
Bye-bye.
Thank you, Mr. Nguyen.
That'll do for Mr. Martinez as well? Okay.
Es todo, señor Martínez.
All right, now, Mr. Zamora, can you hear me? Mr. Juan Zamora? Can Rick call his office?
Judge, for the record, I've already called his office twice, and the staff indicated that he would be logging in.
He's there.
Good
All right,
morning,
let
good
me-
morning, Judge. Let me
Yes.
get Mr. Zamora for you. One second.
Okay, thank you. Thank you. What are we gonna do? This one, plea? It'll be a plea.
Judge,
Yes.
CR 21-02840, Noah Isaac Lopez. On that one, it was a PTD, but I had sent the Zoom information to Attorney Carlos Galvan. That's who I was showing. But Mr. Lopez is now on the case, and his client was not able to appear today since he didn't know it was going to be on the docket.
That's fine. We'll just reset that for next week.
Okay,
Okay,
that'll be a reset. So it'll be a reset on Noah Lopez,
okay.
CR 21-02-840D, reset.
We just need Mr. Zamora.
All right, thank you.
Yes.
All right, Mr. Zamora, good morning, sir.
Good morning, Judge.
Yes, sir. You represent Cristina Rodriguez.
That's correct, Judge. She was actually pleading to the felony this morning, but she has some other attorney that she retained on that. And I guess she's still in that court, Judge.
Oh, okay. So she's still busy with the felony court thing. So I don't see her
Yes,
in
sir.
the waiting. I don't see her in the waiting
We'll
room.
reset it for next week.
All right, it'll be a reset for next week, Mr. Zamora.
Thank you, Your Honor. May I be excused?
Yes,
What
sir,
date?
you're excused. Yeah, you're excused. Have a great day, okay, sir?
What date next week, Judge?
You have a date?
I don't know. We'll email
Yeah,
him.
we'll email you the date. It'll be next week. But we
Thank
don't
you,
know
Your
yet.
Honor.
Thank you. Bye-bye.
Bye.
That takes care of the criminal docket.
All right, now let's continue. Is that it for Mr. Nguyen?
Yes.
Thank you, sir. You're excused. Ms. Ramirez also?
Yes.
Thank you, ma'am. You're excused. Bye-bye. Bye. Let's see. Let's go to civil here. All right.
Where's Pete?
The Flores is there. I don't see Pete.
He was on.
He was
Judge,
on.
He did text me that he should be on in a minute, that he was in another court.
Another court. Okay. All right. All right. Good.
Okay.
So let me see if I can get another civil case here.
Sure. I'll be on standby, Judge.
Okay. Thank you. Miss Aguilar, and who else?
That's number 4 and 5. That's a TRO.
Okay. By yourself?
I don't, unless there's somebody. I don't show.
All right, Miss Aguilar.
Morning, Judge.
Yes, ma'am. Good morning, Miss Aguilar. I think you're here on the matter of the marriage of Jessica Jimenez and Jaime Perales.
Yes, Your Honor. I know that my client, she's in my waiting room.
Okay.
She's here. Yeah, she hasn't been let in, as my assistant saying, but I don't know if the respondent, he hasn't filed an answer. He hasn't contacted my office. I don't know if he's here. He did tell her he hired a lawyer.
Judge,
And that would,
but
yes, Rick.
just Judge, for the record, the respondent Jaime Perales is here at the courthouse outside our office. I have instructed him to log in. He should be logged in. I provided the Zoom info for this respondent.
Okay.
He does not have an attorney, but I did tell him to log in.
Okay.
We need to know what the name is.
Jaime Perales. Let me go check with him real quick to see if he's logged in
Yes.
under another name.
Okay, Rick. Okay.
my client should be Jessica Jimenez.
Right. She's
Or
in
it
here.
might be under my, or it might
She's
be
in-
under my law.
All right. She's already there. She's already in. Okay. Jessica Jimenez. There she is. The case number is 1577. She's got 1777.
So, sorry.
Not a problem, but she's the only other Jessica left in the waiting room. Okay, let's see here. Rick's working on the Perales.
Yes, sir.
Okay, there's Jessica right there. And I think her cost number is F1777, and I think it should be 1577. But not a problem. That is Jessica.
Our mistake, Your Honor. Sorry, I
Okay,
apologize.
no problem, no problem. I think she's the same person, okay. We're waiting on Jaime Perales, who made it in person to the courtroom. Yes, sir.
Judge, I've made contact with Mr. Perales. He's indicated to me he's logged in under a phone by the name of Perla Pulido.
Okay, we see Perla's phone. All right, there you go. All right, there it is. I think it's Perla's phone right there, Mr. Perales. Can you hear me, Mr. Perales?
No, he does not have audio.
Okay, he doesn't have audio now.
My client did say he didn't speak English. She doesn't either, Your Honor. I have my assistant translating for her what's occurring, but she did advise me he doesn't speak English.
Okay. Well, he doesn't have the audio.
He will require interpreting, Judge, FYI.
Okay, but Rick, he doesn't have audio.
Okay. We're checking on that right now, Judge. Stand by.
All right. All right, Rick.
Okay, there you go. No, he needs to unmute.
Okay, now he needs to unmute.
Necesita oprimir el botón para volumen, por favor. Oprima el botón de volumen.
Yeah, he needs to.
Para sonido.
He needs to unmute.
Okay, ya está.
Okay.
All right, there we go. Jaime Perales, right?
¿Este es Jaime Perales?
Sí.
Yes.
All right, good morning, sir. And
Buenos días.
And we have Jessica Jimenez already on the
Buenos
screen
días.
as well.
Do you have an attorney?
Okay. Mr. Perales, do you have an attorney?
Señor Perales, ¿tiene abogado?
No.
Okay, were you going to get one or no, sir?
¿Va a ocupar abogado?
No, no creo.
No, I don't believe so.
Okay, Ms. Aguilar, what are we here for?
Judge, we filed a petition for divorce with a request for a temporary restraining order. And our immediate concern, Your Honor, is that Mr. Perales kicked my client and the 3 children who are 13, 9, and 1 out of the home, and he's staying there. She has no place to live. She is with her mom, but basically there's no room there. She just has nowhere else to go. So she is essentially homeless. Mr. Perales works for Spectrum. We believe he makes about $1,000 a week because he also does odd work for DirecTV and Dish Network. So he has the means to support himself, Your Honor. So we would ask that my client get exclusive use of the home in the temporary orders. We also have asked, Your Honor, that he pay child support because my client hasn't worked in 4 years. And even when she did work, it was part-time and as a daycare worker at a fitness place. It was a short-lived job. So she has no means of support. Based on $1,000 a week, child support should be $1,088. That's what we're asking the court to order today. Your Honor, I haven't discussed with him, but we're willing to do standard visitation without overnight for the older 2. And the reason we don't want overnight, Your Honor, as you'll see in our declaration, and I can have her testify, we've stated that Mr. Perales drinks a lot and drinks heavily, especially at night. So we don't want the kids exposed to that. And the youngest child, Your Honor, is 1. For that child, we would ask that the visits occur on 1st, 3rd, and 5th at Chuck E. Cheese or a similar location every other Saturday from 4 to 6.
Every other from 4 to 6, saying?
For the baby, yes, sir.
For the baby, for the 1-year-old. Okay. And that's every other Saturday. But for the other ones, you said 1st, 3rd, and 5th weekend?
Yes, but days only, Your Honor. I mean, we could do like 10 a.m. to 8 p.m. or something like that, but we just don't want overnight due to the drinking issues.
Señor Perales, lo que la abogada de su esposa le está pidiendo a la corte son órdenes temporales. Dice que hay 3 niños del matrimonio de la edad de 13, de 9 y de 1. Dice que usted trabaja con Spectrum y usted gana como $1,000 por semana más o menos porque también hace trabajos con DirecTV. Ella está pidiéndole a la corte temporalmente mantenimiento para los niños en la cantidad de $1,088 de mantenimiento para los niños. Puede visitar con los niños grandes, pero no con la que tiene 1 año. La que tiene 1 año no quieren que se quede en la noche y puede ver no sé si es hombre o mujer, la de 1 año. La puede ver de 4 a 6, la primer, tercer y quinta fin de semana o sábado.
de cada mes en Chuck E. Cheese. También están pidiendo de que su esposa tenga posesión de la casa para que viva allí con los niños mientras este divorcio se arregle. Están diciendo también que usted toma mucho y ese es la razón en cual están pidiendo esto ahorita temporalmente.
Pues yo ya no estoy viviendo en la casa. Buenos días primero. Yo
Good
ya no
morning
estoy
first. I'm not living at the house anymore.
Okay. Is it a house or is it an apartment? What is it?
¿Qué es? ¿Casa? ¿Apartamento? ¿Qué es?
Es una casa.
It's a house.
Okay. And it's Miss Aguilar, has it been paid for? I mean, is it got a mortgage or what?
I need to ask my client, Your Honor, but if it is owed, and I think it is, we would ask that he continue making that payment as well.
Señor Perales, ¿la casa se debe?
Sí, se
¿O
está pagando
renta?
Se está pagando el pago de la casa.
We're paying the house payment.
Okay. How much is that?
¿Qué tanto es?
557 el mes.
$557 a month.
Okay. All right. Were you going to ask questions of Miss Jimenez?
I can, Your Honor.
Okay. Miss Jimenez needs to unmute. Good morning, ma'am. Can you hear me?
Buenos días. ¿Escucha al juez?
Okay, she needs
Necesita hablar. There's no sound.
There's no sound. We need audio.
Yeah, I'm telling my staff to see if the audio's, well, it should be working.
Mm-hmm. She still needs audio, right?
Señora, ¿escucha?
Escucho, no sé si ustedes me escuchan.
No, necesita subirle, que le suban el volumen a las bocinas, por favor. Si está alguien ahí con usted, que suba la bocina. El volumen de la bocina. O acérquese más a al micrófono de la computadora. ¿Diga algo? No.
Judge, I'll move her over here to my office.
Yes.
Let me move her over.
All right.
Okay, Judge, we're here.
Okay, you were asking some questions, right, ma'am?
Yes, Your Honor.
All right. Miss Jimenez, you swear the testimony.
Levante su mano derecha.
You swear the testimony you're about to give would be the truth, the whole truth, and nothing but the truth?
¿Usted jura que el testimonio que va a dar es la verdad, solamente la verdad y nada más que la verdad?
Sí, lo juro.
Yes, I swear.
All right.
Puede bajar su mano.
Okay, go ahead, Miss Aguilar.
Ms. Jimenez, you heard what I told the judge about the current situation?
¿Usted oyó lo que yo le dije al juez tocante a la condición ahorita?
Sí, todos.
Yes. Yes, I heard.
And is everything I said true and correct?
¿Y todo lo que yo dije es cierto y correcto?
Es todo correcto.
Everything is correct.
And you're asking to move into the home right now, correct?
Y usted está pidiendo que usted se mueva a la casa ahorita, ¿correcto? Correct.
Correcto.
And you want exclusive use. You don't want him to be able to come over and stay in the home as well, correct?
Y usted quiere usar la casa exclusivamente. Usted no quiere que él esté viviendo allí.
Correcto.
Correct.
Okay, and you don't work right now, do you?
Usted ahorita no trabaja, ¿verdad?
No, solo
No.
cuido a mis hijos.
I only take care of my children.
And when was the last time you worked?
¿Cuándo fue la última vez que usted trabajó?
Ya tiene, creo que fue como en el 2018-19, pero fue un part-time en un gimnasio.
Maybe 2018, 2019, but it was only part-time at a gym.
Okay, and Mr. Perales works for Spectrum?
¿El señor Perales trabaja con Spectrum?
Sí.
Señora,
Y aparte, tiene otro trabajo que hace en DirecTV.
he also has another job where he does DirecTV.
Do you know how much he earns with Spectrum?
¿Sabe usted qué tanto gana él con Spectrum?
Con Spectrum tengo más o menos que iba a ganar $20 la hora, porque empezó apenas el 11 de abril.
With Spectrum, I I knew that he was going to be making $20 an hour because he just started working with them on April 11th.
And does he also work on Saturdays?
Él también trabaja los sábados.
Pues tengo entendido que trabaja, ese como cuando ocurrió esto que él me corrió, después entró ese nuevo trabajo Spectrum y no sé cómo está manejando, si es de lunes a viernes, pero él los días que descansa los maneja en el otro trabajo en el DirecTV.
Well, I really don't know because this is a new job and he kicked me out, so I really don't know his schedule. I don't know if he works Monday through Friday. I do know that the days that he's off, he does work in another job.
And while this temporary order is pending, you want him to pay child support, correct?
Y mientras estas órdenes temporales estén pendientes, usted quiere que pague mantenimiento, ¿correcto?
Correcto.
Okay,
Correct.
and you also, sorry, and you also want the visits to be day visits only, is that correct?
Y usted también quiere que las visitaciones con los niños sean nada más durante el día.
Sí, correcto.
Yes, correct.
And that's only for James and Catherine, correct?
Y eso sería nada más para James y Catherine.
Sí,
¿Correcto? Yes.
And they are 13 years old and 9 years old, correct?
Y ellos tienen 13 y 9. ¿Necesita contestar la pregunta, señora?
Va a cumplir 13 en septiembre.
He's going to be 13 in September.
Okay, and why is it that you don't want overnight visits?
Porque es que no quiere que tenga visitas y se quede en la noche.
¿La razón? O básicamente la razón es porque él, como le comento, él toma mucho, él es una persona muy impulsiva y pues más que nada ofende y no quiero que haga eso con los niños en las noches.
Basically because he drinks a lot and I don't want the kids to see
aggressive.
that. And he's aggressive.
Okay, and Joseph is only 1 year old right now, correct?
Y Joseph tiene 1 año, ¿verdad?
1 año y 7 meses.
1 year and 7 months.
Okay, and for Joseph, you're okay with him seeing him on the same weekends he has the other 2 children, but only on Saturdays and from 4 to 6, is that correct?
Y con Joseph no tiene problema usted de que él también lo vea, pero nada más los sábados de las 4 a las 6.
Is this every other Saturday or every Saturday?
The first.
Oh, first.
Sería el primer, tercer y quinto sábado del mes. ¿Es correcto eso?
Sí.
Okay.
Yes.
Okay, and you would want that to be supervised, correct?
Y usted quiere que esta visita sea supervisada.
Correcto.
Correct.
And Chuck E. Cheese in Westaco would be okay?
Sí,
y ahí en Chuck E. Cheese en Westaco estaría bien?
Sí, correcto.
Yes, correct.
Your Honor, I have no further questions. Actually, one more. Ms. Jimenez, do you have the ability to pay for the home?
Yeah. Señora Jiménez, ¿usted puede pagar la nota de la casa?
No, no cuento con dinero.
No, I don't have any money.
And you did ask for spousal support in this petition, correct?
Y usted sí pidió mantenimiento para usted en esta petición, ¿correcto?
Sí, correcto.
Yes, correct.
And you asked that Mr. Perales make the house payment, correct?
Y usted está pidiendo que el señor Perales pague la nota de la casa.
Sí, correcto.
Yes, correct.
And would you also ask that he pay the utility bills?
También que pague los biles de luz y agua. ¿Necesita contestar, señora?
Sí,
Yes.
correcto.
Yes, correct.
I have no further questions for my client, ma'am.
Okay, were you gonna ask any questions of Mr. Perales?
No, Your Honor.
I'm sorry?
No.
No question, Mr. Perales? Okay. Mr. Perales, did you want to say something, sir?
Señor Perales, ¿quiere usted decir algo?
Sí, buenos días, señor juez.
Yes,
No
good
sé
morning,
por
Judge.
qué la señora está diciendo que tengo 2 trabajos y está diciendo que estoy ganando esa cantidad cuando no es cierto. Acabo
Okay,
de
un
entrar a
momentito,
trabajar.
déjeme traducirlo en inglés.
Okay.
I don't know why the lady's saying that I have 2 jobs when that's not true. Okay.
Ahorita,
Siga.
ahorita entré el 11 de abril a Spectrum y nada más estoy trabajando en Spectrum.
Right now, I started with Spectrum on April 11th, and right now I'm only working with Spectrum.
Y como dijo ella, voy a ganar $20 la hora.
And like she says, I'm gonna be making $20 an hour.
Y yo le puedo dar la manutención que me pide el Estado, pero esa cantidad que ella dice no la puedo sacar, no la voy a sacar ni yo.
And I can give her a child support or whatever the state requires, but that amount, not even I am gonna make.
Y lo de la casa, yo sé que ella ahorita no está trabajando. Yo le puedo ayudar a ella con el pago de la casa 2 meses para que ella en ese tiempo ella se pueda encontrar un trabajo y con lo de la manutención que me va a quitar.
And in reference to the house payment, I can help her for 2 months until she starts looking for a job. And with the child support that I'm going to give her.
Y le puedo ayudar en lo que consigue trabajo, pero los biles y eso, pues ella lo puede solventar.
And I can help her while she looks for a job, but in reference to the bills.
Yo ya no estoy en la casa, so ella se puede meter, ella puede regresar.
I'm not there at the house anymore, so she can return.
Okay. Okay, this is just temporary, Mr. Perez. And then when the divorce, as the divorce is going on, there'll be discovery between both parties to see if, in fact, you only work at Spectrum or you have any other jobs or not. You may have to answer some questions or something that the other attorney is going to be propounding to you. So for right now, it's just temporary, hopefully for a month or two, and then it'll be final after that.
Señor Perales, estas órdenes que la corte haga hoy es nada más temporal. Necesito que entienda que son órdenes temporales nada más. La abogada de su esposa le va a mandar a usted unas preguntas. Es importante de que usted conteste esas preguntas. Usted tiene que darle información bajo juramento, tiene que darle información de que si es cierto que nada más trabaja con una compañía, si está trabajando con otras compañías, tiene usted que enseñar todo eso. Y es lo que va a determinar qué tanto va a ser el mantenimiento de los niños. Pero esto es nada más temporal.
Okay, Ms. Aguilar, assuming on the 20 hours, 40 hours on Spectrum, how much would that be?
880.
Okay.
880.
Only with Spectrum? At $20
That's
an hour?
$20 an hour, 40 hours a week. I know she told me that he works overtime, but that's based on 20 hours, 40 hours a week.
Okay, but we can only go, I guess, right now with Spectrum. And then after that, when we do discovery, if it's more, we'll adjust it or whatever. So just based on Spectrum at 20 hours, $20 an hour is how much now?
880 is the child support for 3 children now.
It'll be the 880 child support per month, okay? And then he'll pay the house mortgage and also the utilities.
Okay, señor Perales, por ley, lo que están haciendo es $20 la hora a 40 horas con Spectrum. Entonces sería por 3 niños, sería 880 de mantenimiento que usted va a estar pagando por los 3 niños y va a pagar la casa y los útiles de la casa.
Right.
La luz, el agua.
Right. That's about it. Yeah. This is just temporary, Mr.
Esto es
Perales.
nada más temporalmente.
And then, like I said, and hopefully when we come back, we can either adjust it or pick it up or go down.
Y cuando regresen, entonces se ajusta, se hace más o se hace menos.
Yes, sir, Mr. Perales. Question. Yeah.
¿Por qué es temporal? ¿Cuánto tiempo?
What's temporarily for how long?
Temporarily, hopefully for a month, maybe 2 months. But the sooner it's settled, the divorce is final, it's over.
Ojalá 1 o 2 meses, pero entre más pronto ustedes lleguen a un acuerdo y finalicen el divorcio.
Yeah.
Okay, una cosa más.
One more thing.
Yeah.
Yo me salí de la casa, pero tengo muchas cosas personales mías.
Yeah, you're entitled to them. You can get them.
I moved out of the house, but I still have a lot of personal things.
Yeah, you can go pick them up.
Usted las puede levantar.
Yeah.
Judge, that being said, my client, he does work for Spectrum. He does the installation of equipment. And he has cameras that have audio and video connections all over the house, including outside and inside. And they're audio and video. We would ask, I mean, obviously he can go to the home and take his stuff, but we would ask that he remove all cameras.
Okay. Okay, did you understand that, Mr.
Ok, señor Perales, lo que está pidiendo la abogada de su esposa es también que dice que usted tiene cámaras que tienen video y tienen audio. Está pidiendo de que todas las cámaras se quiten en este momento.
Ok, las cámaras ya no están funcionando, están desconectadas. Quitarlas me tomaría un día.
Okay, the cameras are not working anymore. They're disconnected. If you want me to remove them, that's going to take me a whole day.
Pero ya no están trabajando. Puedo irlas a quitar eventualmente un día que tenga libre.
But they're not working. I can go remove them whenever I have a free day.
Okay, make arrangements with you, Ms. Aguilar.
Okay, Your Honor. Your Honor, I don't have his contact info. I don't know if he has a phone, an email. If he's not planning to get a lawyer, can I get his contact info?
Okay.
Señor, si usted no piensa en ocupar abogado, la abogada de su esposa necesita cómo comunicarse con usted, un teléfono, un email, algo para comunicarse con usted.
Okay, sí. Mi número es 956 272 9489.
9489. 956-272-9489.
Okay.
Does he have an email?
¿Tiene correo electrónico?
Sí, es Jaime_ Perales _ Ochoa @hotmail.com.
Ochoa @hotmail.com.
Yeah, Jaime _Perales _Ochoa @hotmail.com.
Okay, so these orders that we're going to be doing, Mr. Perales, will be reduced to writing, and you should be getting a copy, okay?
So estas órdenes que la corte ha hecho hoy se van a reducir en escrito,
And
y
you will
ya
get,
que el juez firme las órdenes, entonces usted recibirá una copia.
but you need to make arrangements to get your personal stuff out of
Pero
there,
usted tiene que hacer arreglos para que saque sus cosas personales,
and at the same time to remove the cameras.
y a la vez para quitar las cámaras.
Yes, Ms. Aguilar.
My client feels like she can't move into the home until he removes the cameras, Your Honor. I don't know if he could do it by like Saturday. Could we?
Okay.
Señor, ¿puede quitar las cámaras el sábado o antes del sábado?
No, porque trabajo de lunes a viernes, pero sí puedo ir el sábado en la tarde.
I work Monday through Friday, but I can go on Saturday.
Okay, Saturday.
Okay, and I just, Your Honor, as far as the visits, what we requested will be given to us on the
Yes.
visitation?
Again, this is temporary, but the sooner you come to an agreement and make it final, it may be the same or different or up or down.
Esto es nada más temporal, señor Perales. Y si el sábado va y quita las cámaras, entonces sería buen tiempo de que también saque sus cosas personales.
Okay.
Pues
Okay.
podría sacar algunas, pero me faltarían otras, pero porque no tengo un lugar estable todavía, pero sí.
Yeah, you make arrangements. Just
Ya,
call the attorney.
nomás haga arreglos.
Yeah, make arrangements with the attorney. Okay.
Haga arreglos con la señora Aguilar.
Judge, and I feel like I just need to say that he not take any major appliances or furniture or anything like that until we have a final hearing.
Okay.
Lo único, señor Perales, es usted no puede sacar cosas grandes como una hielera, un sofá, la recámara, hasta que no se haga todo final. Lo único que va a sacar es nada más ropa, joyas, zapatos, cosas personales de usted.
Yeah, herramienta, whatever
Sí,
you have.
lo que usted usa para trabajar, la herramienta.
Okay.
Yo tengo ella tiene su recámara, los niños tienen su recámara, y yo agarré una recámara para mí que agarré. Esa la tengo en la sala, y esa sí la quisiera sacar.
Okay, he's saying he's got a bedroom set in the living room. He says that is his. He would like to get that one out.
He was okay with that, Your Honor, yes.
Okay, está bien.
Está bien, es así.
Okay.
Otra cosa, yo no pude hablar con la señora Jiménez para arreglar esto bien. porque no me dio oportunidad. Yo, si ella en la orden que me puso, quiere que yo pague los gastos de su abogada, pues yo no quiero eso.
Okay, that will be determined at the final hearing at the end, okay?
Eso se va a determinar en la audiencia final.
Right now, there's
Ahorita no va a ordenar nada.
as far as the fees for attorney
Tocante a
fees.
los pagos de la señora Aguilar.
Okay. All righty, sir. Good luck with that. This is just temporary.
Suerte. Esto es nada más
If you have any questions, just call the attorney, okay?
Si tiene preguntas, nada más llámele a la abogada.
All right. Okay. Thank you all so much. You may be excused. Good luck, everybody.
Suerte. Number 2.
Okay. Thank you, Ms. Aguilar. You may be excused. Thank you. Number 2. Where are we? It's still morning. It's still morning. All right. Let's see here. We have Mr. Espinosa and Mr. Flores.
Morning, Judge.
Good morning, folks. We're here on F0. Wait a minute. Let me see. Yeah, it's F0048-20-4 in the matter of the marriage of Maria Navarro and Jesus Navarro. Is that correct, gentlemen?
Yes, sir.
All right. What do we have here? What are we looking at?
Judge, in behalf of Mr. Navarro Roby Flores, we filed a motion for additional temporary orders regarding the property. And if I can give the court a little bit of background to try to get us there. Back in February, September 15th of 2021, there was an order regarding property to the Swallow property in McAllen and the property in San Antonio. And at that point in time, repairs were ordered to be made, split between the parties because each of the parties had received like $100,000 from the sale of their previous home. Having said that, conversations went back and forth in reference to getting the monies that were going to be needed. They could talk directly to the contractor and so on and so forth. Ms. Navarro, on January 11th, she never made the repairs, never provided the money, opted to make a recommendation or offer of settlement for my client, and this was on January 11th of this year, to pick one of the two properties, either the San Antonio property or the Swallow property. And they attached the appraisals associated to those properties.
Okay.
We elected at that time, since the repairs weren't being made, mind you, the tenant's lease had ended. That's why the repairs had to be made. And we had also agreed that the properties wouldn't be rented because the idea was to sell them. But there were mortgages on these properties, which my client has been paying. So when the offer was made on January 11th, we agreed to elect the property in San Antonio, and in their proposal, they said, we'll prepare a gift deed. She would be awarded the Swallow property, and much like the previous order, he would have a first right of refusal on that Swallow property if and when she decided to sell it. Well, moving forward, we accepted that offer, and we said, okay, let's do it. Somewhere around March the 4th, and I can show you these exhibits. I filed them with the court. In March 4th, he said, by the way, we need the payoffs on the properties, and we sent it to him. And again, we reiterated, we're ready to do this deal because the mortgages are being paid by my client. The properties couldn't be leased. She did not want to make the investment into the San Antonio property. So we filed our motion for additional temporary orders. And in the motion, we lay out the property that she would be keeping has a higher value. The property she was going to be keeping does have a bigger mortgage. But it doesn't need the repairs that the San Antonio property had, but either way, they asked us to elect, and we did. Having said that, we sent them the order outlining the first right of refusal that was discussed, outlining that we would take the San Antonio property, they would gift it to us, we would gift them the Swallow property, along with the provision with the first right of refusal if and when she decided to sell it. Because they said, well, she may not want to sell it. We said, okay. You know, if she decides that she wants to keep it, she can, but somewhere down the road, if she decides to sell it, he has a first right of refusal. Along with that came the payment of the debt, because my client's been paying, as I said, both mortgages, the $13,000 and the $62,000 respectively. Now they're saying, well, we don't, you know, we don't want to do it. Their response basically says, if I'm reading it correctly, says that they just don't want to do it. They don't say why, but we've accepted their offer. So now we're asking the court for additional temporary orders to order that which the parties negotiated and has been accepted. We're asking that we take the property in San Antonio and its debt. We'll do the repairs, transfer the gift deed to us. We'll prepare the gift deed to her on the Swallow property, and she takes that debt because, you know, she gave us the option. And we took it. There's still another property out there. It doesn't dispose of the case, but it gets us one step closer, because since the temporary order back in February, hold on. Let me make sure I have the right date here. No, the additional temporary order date. The agreed order from September 15th, 2021, and the additional order, I mean, my client's been paying now since September to the present date, all the mortgages. We can't rent them by the previous agreement. Can you share a screen with me, Judge?
All right, share a screen with you. Let me see here. Let me get it.
Sure.
All right.
And let me get to that. Here's their January 11th letter, basically saying, our client, Ms. Navarro, proposed that your client choose either the following as a matter resolving partial settlement. Creekside, Swallow. They attach the appraisals for each real property to your client and review and assist him in choosing the property of his choice. After his election of property, we can proceed with the gift deed, special warranty, and waiver of community private rights that either party can maintain or dispose of said properties. So these were going to be mutual exchanges. All other community properties and subproperties will remain in further negotiation or court decision. Fine, didn't have a problem with that.
Mm-hmm.
We accepted it. And so let me go to the next one. Give me a second, sorry.
Did you put the actual letter on the screen?
Yes, I did. That was the letter.
Because I only saw the January, I saw the...
Yeah, that's the January 11th letter.
I didn't see the letter. I saw only the date that there was a letter.
Oh, I'm sorry. Can you see it? You can't see it there. Let me share the screen with you, Judge. I'm sorry.
Which was essentially the offer.
Yeah, do you see
there
it?
It is. There it is. Yeah. Now I see it.
So
okay.
Our client is allowed to propose that your client can choose
either
the following as a partial settlement.
Okay, you got the San Antonio and McAllen property, okay?
Right. And they attach the appraisals. We can proceed with a gift deed.
There you go. So, okay, I got it.
So we've agreed to it. We've agreed that he'll have a right of first refusal on the Swallow property, just like our previous order of September, if that's what she chooses to do. I mean, if she decides to rent it, well, she rents it. If she decides to keep it, she keeps it. If she decides to sell it 5 years from now, he has a first right of refusal. She doesn't lose anything in translation. So we submitted the order based on this agreement for signature. And since we didn't get an agreement, since they said, no, we don't want to do it. Well, we said, well, wait a minute. I mean, first of all, if you go back to the September 15th letter, let me get you the order. Let me get you to the order. So when we got into this order back on September 15th, and I'm going to scroll down a little bit, we had gotten agreement back then, or the court ordered that these properties basically could be sold, but there was repairs to be done on this Swallow property. When we approached Ms. Navarro about making those repairs, and those repairs supposed to be split 50-50, because remember, both parties had received $100,000 to do the repairs.
Okay.
He didn't really want to do it. So come January, she makes us that offer by and through her lawyer to, pick, and we can get rid of that issue. So what we're respectfully asking the court to do is to ratify that agreement. She will execute a gift deed to my client. He'll be responsible to the debt on the property, any repairs that he has to make. If he decides to sell it, rent it, that's his thing. The same thing with her on her Swallow property.
Okay.
She can rent it, sell it, remodel it, keep it, whatever she wants to do with it. And if she decides to sell it in the future pursuant to the order that already is in place, he has a first right of refusal to purchase it, be it next month or 15 years from now. Who knows what she's going to do with it? I don't know. She may want to rent it. She may want to give it to one of her kids. That first refusal may never come up to play, but she doesn't lose anything. So based on those representations and agreements, Judge, we respectfully request that the court enter an order granting this agreement, that the gift deeds be exchanged, that he be responsible for any debt, remodel, anything associated with the San Antonio property, and vice versa, that she be responsible for anything associated to the Swallow property. That is the extent of our motion for additional temporary orders that we filed on April 13th.
Okay.
When we weren't able to get this, because now we're just stagnant.
All right, Mr. Espinosa.
Judge Peter Espinosa for Maria Navarro. I think what Mr. Flores fails to notify the court is that when we wrote that letter, it had a 10-day expiration date, 10 days to accept the offer. And that date, the letter he just showed you was dated January 11th.
Right.
He responded on January 24th. So that was, if my calculator is correct, that's about 13 days later. So that offer is negated under the contract of law. If he doesn't accept the offer within those 10 days, and it was the letter he's just showing you, Judge, right now. And I can show it to you too, but he failed to read that last sentence. It says, we look forward to your response and we will allow 10 days for this offer. He responded on the 13th day. So that offer is already off. And Judge, we were just trying to, I will agree that we're trying to sell both properties. One of them needed more work than the other. And what Ms. Navarro didn't have the money to repair. So what we wanted to do was, well, let's sell both properties. Ms. Navarro has a 4% real estate agent. And whatever it sells for, of course, it would be some agreed value to sell. And then they can split the properties. We have two properties to worry about, the San Antonio and the McAllen. So what we're asking for, Judge, is to have both property sold. Now, we made our argument at the last hearing that we didn't have the funds to pay for the
Repairs.
Yeah, repairs. And this honorable court said, well, you've got to pay repairs up front, and then you can sell them. Well, Miss Navarro didn't have the funds to repair, so that's why we tried to negotiate something. But nothing was ever accepted within the time limit that we made the offer. And so what we're asking for is, yes, we want to follow the court's order to sell the properties, but the repairs either to be taken from the sale proceeds or sold as is. The market is very hot right now, Judge. Homes are being sold as is because there's just not enough homes in the market, and that's general knowledge in our economy. So that's what we're asking at this point, for the court to say, let's just sell both properties, split the proceeds, and then, the other issues we have, there's a child support issue that hasn't been paid in 2 years. So that's another issue we need to worry about. There's another house that Ms. Navarro can take in lieu of those child support that's owed. And the value of the houses that's increased since our last hearing has increased approximately 18%. And we entered that as an exhibit. But Judge, do you want me to show you the letter where it says the 10 days that we offered? I can show it to you. I don't know. We do have a share screen option. So if I can,
You have a share screen there?
Yes. So Judge, if you can see this is the exact letter Mr. Flores was showing you.
All right.
You look at the very, very bottom, and I'll try to increase this because my vision here is not 100%. It says, very last sentence, we look forward to your response and will allow 10 days for this offer.
Okay.
And he failed to tell you that he responded on 13th day later. And so as far as, first right of refusal, yes, my client can sell, but she's going to have an offer for him at around $385,000 for that house because it's increased in value. And so if he's willing to pay $385,000 for that house, then she may accept it. She can probably sell it for more, but that's kind of what, that's what the first right of refusal is. Anyway, Judge, we're just asking for, if the court's going to order, make a ruling today, just to have both houses sold.
Okay. You said a previous order of the court was to have both homes sold?
Judge, look, first of all, he doesn't have a motion before the court, and let me go back just a little bit. Let's go back to the order so I can clarify something.
Let's see if I can find the order here.
Give me a second.
I think an order was made last year, I guess, where both homes were supposed to be sold.
Well, yes, Judge.
Yes, sir, Judge, but it was done under a certain provision, and I'll get you to that order. We've already had a hearing on how this property is to be disposed of. He's now trying to change the terms of that agreement, and I'm going to show you that. So here's the shared screen.
Okay.
She had $100,000, first of all, in her possession.
Judge, I'm going to object to that.
In here, my client is prohibited from leasing the properties, and they're to be sold. And more importantly, it was ordered that the Creekside property was to be repaired, with the parties splitting the cost of the repairs because they weren't going to be sold as is. You actually, in your ruling, we can go back to the record, you said, Mr. Espinosa, obviously a house is going to have more value, you can get more money for it if they do the repairs that need to be done versus selling as is. He made that same argument before, and you ordered that the repairs be made. When we finished with that, they opted not to do that, and that's why they made the offer. Then, just so the court is aware, now let me get to that document. Mr. Espinosa, I'm sorry, was was,
I get confused.
you're better looking than able. You're okay.
Thank you.
I'll give you that.
Okay.
On March 4th, we send him a letter, and he responds back saying, "Hey, he doesn't say that we're not in agreement. He says, our office sends your question regarding the community property owned by the parties, by the clients. As I discussed with Rose today, we are requesting that your client disclose the remaining balances," which was done. I mean, think about it, Judge. They're trying to tell you that somehow she's making an offer to pick a property, but that she didn't know what the liabilities were. We reaffirmed it. We resent it back to him and again said, let's do this deal. And by the way, he has that first right of refusal, right? So no, it didn't end after 10 days. He's sending us a letter back on March 4th saying, well, I need to see the documents of the payoffs, which we sent to him and which he had. And they would have had them not only on March 9th, they would have had them when they made the offer back in January. She didn't make the repairs. She hasn't put the money in. It's not in our motion any more than their motion to modify is filed today. She hasn't even been paying the 1/2 mortgage pursuant to the orders on the Taylor property. So, I mean, so my client has been stuck paying thousands of dollars over 9 months. He was prohibited because of their request not to rent the properties. I mean, if we would have known she wasn't going to pay the money as she was ordered to do the repairs, one, we could have tried to rent the Swallow property or done something. But the agreement was they were going to try to sell both properties. They made this offer, we've accepted it. And we're willing to do it, but we got to move. And he's willing to absorb all the costs to do the remodel, but she wants to sit back and pay nothing. So, I mean, I guess I can file a motion tomorrow and say, okay, she starts paying the property on Swallow because she isn't paying it. She can pay the property. She's already been ordered to pay 1/2 the mortgage on the Taylor property. She isn't paying it. And my poor client's over here having to pay the mortgage on San Antonio and now potentially absorbing all the costs to try to maximize their profit. Look, she made that offer on January 11th because she knew that the Swallow property had more value and she didn't want to make the outlay of costs to improve the San Antonio property to sell it, which my client was willing to do back in September, and you ordered for them to do it. Now, 6 months later, 7 months later, 7 months of mortgage payments on 2 properties, the inability to lease and the inability to do the repair for her failure to pay her 1/2, you know, at some point in time, equity has to set in. And so we're asking the court to enforce the agreement, the acceptance of that agreement. My client will do his repairs. We execute warranty deeds. We get those properties out of our hair. She can do what she wants with Swallow. She wants to sell it. Pete just told you he could sell it for $385,000. By golly, go do it. And if my client wants to offer a first right of refusal because someone makes that kind of offer, great. But if he doesn't, hey, she's going to make money. According to Pete, that property is worth a lot more money today. So I don't get it. So in the meantime, he wants the benefit of the payments, the benefit of the equity that's being built. And now I'm going to sit on Judge, by the way, just sell the properties as is. Well, that wasn't the intent of that order. The order is clear and specific. Do the repairs. She opted not to do them.
And Judge, if I can just share the letter that Mr. Flores sent me. Let's see if I can find it here. So it's pretty clear that the date here says January 24th. If you remember, I said, I'm going to allow you 10 days. Here we are, January 24th. In his letter, it says, in your response dated January 11th. So the 10 days are gone. That any kind of offers is already under basic contract law is outdated. And then he does a counter offer. And so he negates.
It's not a counter offer.
What says it right there, Roby? it responds to your letter response dated January 11th. Our client has reviewed the offer and has counter offered. So you're already negating the January 10th letter because first of all, you're outside the 10-day
Because
window.
we had a first right of refusal by order.
Okay. But you're trying to enforce the January 10th letter, which is outdated already here, and he's counter offering. So Judge, we want to go by the original temporary order the court ordered, but we just didn't have the money to pay for the repairs. And so I
So
think
now they do?
Well, reasonably, I think it would be sell both houses and split the proceeds. Both of them have a mortgage. Judge, if she ends up with Swallow, she ends up with a $60,000 debt. If he ends up with San Antonio house, he only has a $10,000 debt. So she still has $60,000 to pay.
But which is worth more?
Well, the house in
Swallow.
In Swallow is worth Swallow's it's worth 327 is what the appraisal said, and then we had an 18%, which is at 385.
And what about the San Antonio home?
San Antonio had a 313.
So it's got less value.
It has less value.
And plus
it's a $75,000 swing if you believe them.
They're both about, the original value was 313 and 327. So now it's about 369 on the San Antonio address. And then there's
there is no evidence that the San Antonio property is worth 369. Mr. Espinosa represented to this court. If you can remove the letter so I can see the court.
No, just based on the values. What are the values? I mean, to sell for this or that, we don't know what it's going to sell for. But the values right now, both properties, Swallow's worth more, right?
What you have, yes. What you have is the appraisals that the Swallow property is worth more.
Okay.
Plus, you have the fact that the San Antonio property needs somewhere between $25,000, $30,000 worth of repairs.
Okay.
By the time it's all said and done, that's why they said pick. You can pick either one. By the time he would have made the repairs, paid the mortgage, it was about going to be even. I think she wanted the Swallow property because it was here. She might choose to live in it. She might choose to, I don't know what she might choose to do. But I mean, in the meantime, Judge, the point they want to gloss over is that 7 months have now gone by of 2 mortgage payments that my client has been paying. So you start looking at those mortgage payments, you're already talking another $20-something thousand in mortgage payments that they don't even want to account for, that had she done what she was supposed to do in September, so that the remodel could have been done and this property in San Antonio could have been sold in November and December, they both would have made some money. They would have paid off the debt and they would have had money in their pocket. But now they're wanting him to eat the costs. They're wanting to continue to pay it. Now they don't want to make the repairs. They want to sell it as is. I mean, it defies the order and the argument that they made back then. They always wanted the Swallow property. We were willing to give it to them, but they liked the fact, well, we didn't do the repairs. He's still paying for them. I mean, you know, Judge, I just don't know how else to put it. I mean, my client's been disadvantaged, and they certainly made an educated decision when they said, pick one. And the negotiations continued through March, and we sent them the order saying we've accepted. And it had the first right of refusal in there that was in the order. Nothing has changed. They were talking back and forth until the last, when they said, we know what the payoffs were. Well, you didn't make that offer not knowing what the payoffs were. You know, I mean.
We did, Judge. We didn't have it. We had no clue what the mortgage was owed. Remember, I'm the third attorney on it. I just got all the documents from Mr. Casares, 2 bank boxes. And so we had to kind of figure it out. So what was all
Judge, is it logical that they wouldn't have known in January what the payoffs were and what the values were? They knew that we're basically even at the end of the day, if with the repairs and the increased value in Swallow property. But that was a ruse because now February, March, April, and May is knocking on the door, and that's 2 more payments coming out of Navarro's pocket, Mr. Navarro's pocket.
But
I mean,
Judge, it's not out of his pocket. It's out of the business that both husband and wife own. It's a community property business.
That's a different issue. We've got different claims there, but without confusing the issues.
Okay. And have you
in
guys
any
mediated
event-
at all with anybody?
We did some mediation, but I don't think we had anybody in the middle. I think we did an informal mediation, if I remember.
Well, Judge, I can turn around and file the motion to enforce and tell her to pay the money and ask for an offset on all the monies that Mr. Navarro's paid because of her lack of due diligence to pay. And we're going to be back there where she's going to owe him about $30,000 on mortgage payments and repair, and then an additional $20,000 to $15,000 on repairs.
Yeah.
And in the meantime, we're going to delay this sale by another 3 months because it ain't going to happen in the next 30, 60,
Well,
90.
You know, honestly, by the sound of it, it sounds like a good deal that Mr. Navarro keeps San Antonio property and she keeps Swallow, because that one has more value. Although it's got $60,000 worth of repairs to be done, the San Antonio one has about 25, but it's worth less. So it would seem to me, and Mr. Espinosa, you're saying that if you can sell it for 380 or something, even as is, that's even more valuable.
Yeah, but there's still a debt, Judge. We have to.
I'm sorry?
There's a $60,000 loan she has to pay on that debt.
But that's going to be the debt that is owed. I mean, it's going to be paid up when you do the sale, if she sells.
Right.
But currently, Mr. Navarro has been paying how much? How many months? 7 months?
He's been paying at least 7 months since even before then, but since the order of September, the monthly mortgage on one house is $1,300. The monthly mortgage on the other house is $1,400. So that's $2,700 a month, almost $3,000. You multiply that by 7 months, that's $21,000 that the delay has been done on the selling of the homes. I mean, we were in agreement to sell them and do the repairs, but they didn't do it. And then they say, here, pick a property. And then we do that. Now they don't want to do it. It's a delay game at great cost to the community and in particular to my client. And we're willing to do the deal. I'm glad he believes that property is worth $385,000. She can keep all the profit on it.
Yeah.
Let's get this done.
Right. But
well, you realize that if for today you were to do that, pick a property each and move on, you still have more property that you're gonna have to divvy up during this divorce, right?
That's correct, Judge. We have a
So it's not like
business
you will. Nobody. I don't think nobody loses by going either way here, because you still can make it up later on with other property. Mr. Navarro may or may not want to get back his payments on the other house, depending on how that division is going to end up at the end. But for right now, even if you do a trade-off, no matter who gets what, it's not over. You still got a long ways to go. But I think, Mr. Flores, you were saying it's a start. It's like a,
Well, I think what's happening, Judge, if we have a final trial, I mean, we're kind of piecemealing it right now. Flores is attempting. Let's do this now. Let's do something later. Do something later. And when we have a final trial, well, we're not going to be able to argue to have part of the San Antonio property if the court divides it now. And so,
Judge, I don't have a problem with them. Well, I mean, she, at the end of the day, if she ends up with $385,000, if anybody's going to have a claim, it's going to be us. But if we give it up now, then we're waiving that claim, and that's okay. But we stop the bleeding of $3,000 of mortgage payments.
Right.
I mean, she can have that profit outright on a
whatever
property
it is. Yeah.
Whatever it is. And we're going to assume the responsibility of repairing the property in San Antonio
and make the best of it.
And make the best of it. I mean,
but the San Antonio property also increases, Judge. Remember, if you're saying, well, this property is worth 385, well, so does San Antonio. It's going to 365.
No. But earlier in the divorce, you all had appraisals. You all had even county appraisals or whatnot. And I think you said one was worth a lot more than the other.
They did formal appraisals.
Only 20,000 more than the other.
Which is the Swallow property. I mean, I don't get it. It's the Swallow property that their formal appraisals gave them more money in their pocket with no repairs to be made, like in the San Antonio property. I mean, unless.
Yeah, San Antonio property had an appraisal also, but it considered
I agree.
any repairs that had to be made also.
No.
That's what I'm looking at. I submitted it to the court. Adam Solis, Sky Valuation Group.
Okay. Well, what I'm saying is no matter which way it goes, I mean, there's still more property out there that's gonna have to be divvy up one way or the other, you know, to help settle the matter.
Yeah, and we're gonna have some child support issues coming up, Judge. That's
and they can raise them, Judge. We're prepared for those. We know we're fine. The only issue before this court right now is this property issue and the monthly mortgages that are being paid and the failure to do the repairs pursuant to your order that she's violated. And then saying that she's willing to say, hey, pick one, and we do. I mean, I think you're starting to see a pattern of what's happening here.
So I think initially somebody said that somebody had $100,000, or was that split between both of them? Or what was it?
Yeah, they had another home. Their main homestead was sold, and both sides received $100,000. That's separate and apart from the money that she receives in child support. That's separate and apart that the money she gets via payroll as part of the agreement that's been going on for 3 years. That she receives. I was 35. Was it 30? I think she receives like $3,500 a month, separate and apart from the child support, plus the $100,000 that she had from that. I mean, this argument that she didn't have the money
to make the repairs.
Yeah, I mean,
Judge, that's kind of inaccurate. She's receiving a paycheck from the work, and he's counting it as his child support.
No, that's not. No, that's not what's happening. She's receiving. She has a monthly payment of $3,500. Like you'll see the temporary order says like it's a leave of absence, and she gets $3,500. Separate and apart from that, he has a separate child support order. But you know, that is what it is, and what's been paid has been paid. We believe that we are current when you see it. The other part, she was ordered to pay 1/2 of the mortgage on Taylor. Guess what? She's not paying that either, and hasn't paid it since the entry of the very first order that she was given that liability. So that's another mortgage payment of like $1,400 that she's not paying.
Judge,
So,
I think we're going to be on the scope here of this original temporary orders modification that Mr. Flores wants to do. But the original temporary orders that the judge, your honor, signed was split the cost of the repairs and sell the both properties. And he has the first right of refusal to buy the house. If he doesn't buy it, then my understanding is the house gets sold, repairs get made. She just didn't have the money to repair. But if there is any repairs, contractors can take the money from the sale of the house. Title companies do that all the time. And
contractors want their money up front. They don't go do work for free. They don't say, yeah, pay me when you sell it. Sure, wink, wink. Lawyers do that too, by the way, Judge. Wait for the outcome, then you can pay us the attorney's fees. Sure, it works that way.
Personal injury lawyers do that.
Oh.
Okay, guys. So the repairs were not made, and now there was an offer to either take one or the other, and now it's sell as is, both properties, right? Is that what it is? That was the third option?
No.
Sell as is, both properties that you all agree on?
No, there is, well, in that September order, the order of property was to make the repairs on the San Antonio property and sell it, split those proceeds. The reason that was going to be done because he had a first right of refusal on the Swallow property. Then the Swallow property was to be sold. He had the idea potentially with the proceeds from the San Antonio property to be able to make an offer to buy out the Swallow property if she didn't get the kind of money, or the offers were of a nature that may not have been beneficial, but he would have had that first right of refusal. There was a method to the madness to sell the San Antonio property first because he had that first right of refusal on the Swallow property. That's why she was supposed to contribute to the repairs. So no, the offer was never to sell both properties. There was a sequence of events. Repairs San Antonio, sell it, split the proceeds, then put the San Antonio property, giving him a first right of refusal. Or a Swallow. That was the order. Since she didn't pay it, that's why she made the offer. She didn't want to put money out. And I guess they figured the Swallow property was worth more money at the end of the day. And that was okay with us. And at the end of the day, if she decides to sell it or keep it, then those are her options. He has a first right of refusal. But, at the end of the day, if she gets $385,000 and my client can't afford it, she's going to make a bunch of money. And that's okay. But in the meantime, here we are, $30,000 worth of debt in mortgage payments. And she gets to sit back and say, oh, well, let's do this deal now. Well, let's just sell them now. Well, that wasn't the order. The order was do that stuff.
Judge,
all right.
Just to remind the court that she can find a 4% real estate contract agent. And if he would have made repairs, he would have got that money back, right? So I know you said the courts should split 50-50, each party pays for the repair. If he was to say, well, I'm going to just pay them all, he would get all that money back through the sale. So she didn't have the funds.
It makes it easy when you say, well, just pay for everything and keep paying the mortgages. Yeah, it's okay. You're going to get it back. Yeah. The idea was to try to get it back up front. It's a lot harder to put in $30,000 than to put in 15 each. And she understood it, but she wanted to hold on to her money. But that wasn't the order. Her order required her to pay it, period. It wasn't an option.
All right, court will take this matter under. By the way, did I even call the case? Let me see here. Yeah, it's cause number F0048-20-4 in the matter of the marriage of Navarro. All right, court will take this matter under advisement, and I'm going to review that. Or that was in the temporary that was signed. What was it?
Yes.
Back
September the 15th of 21.
Okay, based on September the 15th, 2021, that we had an order already. Okay, I'm gonna look at that order and look at what you all presented today, and hopefully I can come up with an idea here. So submit your proposed orders, okay?
Yes, sir.
Thank you,
All
Judge.
right, you're excused. Thank you all very much. Have a great day.
Thank you, Judge. If I may, I have another case. It should be a quick announcement. So
sure.
Yes, it's number.
Sure, that's number 6, F2660-21-4 in the interest of Ava Arispe.
Yes, Judge.
Can I be excused, Judge?
You're excused. Thank you.
Thank you, Judge.
Yes, sir.
Judge Peter Espinosa for Ms. Benitez. We have filed a motion to withdraw. I don't even think she appeared in court. I don't know if your court sees her on the Zoom.
What's her name?
Her name is Flor de Lisa Benitez. Flor de Lisa Benitez.
You know what? She might have been earlier because I remember that name, but she's not there right now.
Okay. Should we just reset it, or I don't know?
It's a motion to withdraw what? You as the attorney?
Yes.
Okay. And let me see here. You want to get a reset there? But I want to make sure. Mr. Espinosa, what was the reason again for the motion to withdraw?
She was unable to communicate with us, Judge. We've been trying to communicate and she's been unavailable. That's been the primary reason.
Motion to withdraw granted, okay?
Thank you, Judge. There's an order.
Submit the order. Yes, sir.
Okay. Nothing further, Judge. Can I be excused?
Maybe excused. Thank you.
All right, thanks.
Number 7.
Number 7.
So close say divorce. They've already submitted the final decree. They have 2 children, $590 on child support. I don't know what they're basing that on.
Okay, how about, who are the people? Let's see. Cause number F4510-21-4 in the matter of the marriage of Rolando Perez and Valeria Ayar. All right. Mr. Perez, you need to unmute. Who do we have here? We got more people there. Okay.
Yeah, hello? Yeah.
Yes. Yes, sir. Can you hear me?
Yes.
All right. And Valeria, can you hear me?
Yes, Your Honor.
All right. This is a pro se divorce, right? You all submitted the decree already?
Yes, sir.
Did you put in an amount of child support? I think it was 550. I'm sorry, 590.
I believe it was 390 a month.
390 a month. Okay. I'll put here. Do you remember, Mr. Perez, what it was? 390 or 590?
No, it's around 390. Yes.
Okay, 390.
That's because they take it away automatically.
Okay, it's already been deducted automatically. And this for 2 children, right?
Yes.
Yes.
For Armani and Timothy?
Yes.
Yes.
Okay, how old are they?
5 years and 4 years old.
All right, 5 and 4. Any properties? Do you have any properties?
No, Your Honor.
No. You all don't have a house or anything like that?
No.
No.
Okay, how about cars or pickup trucks?
I have mine leased.
Oh, yours is a lease?
Yeah.
What is it?
22 Ford Maverick.
22 Ford. And what do you have, Miss Valeria?
I have a lease as well. It's a Ford Explorer.
Okay, you have a lease, Ford Explorer. Okay. You're all going to continue paying each other's lease, right?
No, we don't pay each other's leases.
No, I mean, you pay your own and he pays his own?
Yes.
That's what I meant. I'm sorry. Okay. Then no property, but you got children and you got an amount on the child support of 390, you said?
Yes, Your Honor.
Okay, one moment. I'm being told to hold on because I think somebody found another number.
Okay.
It doesn't look like 390? All right. Okay. Yeah, it's supposed to be a 390, but it looks like a 590. That's what I'm thinking. Let me see. I'm gonna see it right now. Okay, we're getting there.
Okay.
Yeah. Yeah, it looks like a 590, but it can also be a 3. So, but you're right. It is the 390. You all meant 390, right?
Excuse me?
You said 390?
Yeah. Yes.
You can see it. Can you see it? It looks like that 5 needs to be corrected, but it's a 3. It's supposed to be a 3, right? 390?
Yeah. 390.
All right. Looks kind of weird, so it's supposed to be 390.
I guess we can fix it.
We'll try to fix it here. All right. Court will take judicial notice of the entire filing, F4510-21-4, in the matter of the marriage of Valeria Ayar and Orlando Perez. Court will hereby dissolve the marriage of petitioner respondent. Court will sign a decree of divorce as presented by the parties. That'll do it. Thank you all very much. Have a good day.
And we're divorced. Is that the final step?
That's it.
Oh, okay.
Wait till
Thank
you get a copy in the, what, you're gonna get e-file or something?
No, it's already. Whenever the clerk sends it, it'll be signed.
They'll send it to them. All right. Well, your divorce is up to date, but the clerk will send you a copy later on, okay?
Okay, yes. Thank you so much.
Yeah, thank you. Bye-bye.
Bye.